जजमेंट है क्या मेरा? जजमेंट नहीं है ना मेरा? कर देते हैं।
Item number 1 to 3.
पैसे अलाउ कर दिया हम देखते छोड़ जाहिर आता
It's a common order for all three.
Yes,
It's
madam.
all the same. Consequently, accordingly, these three criminal petitions stands allowed. Consequently, the order of cognizance dated 9/3/2016, the order dated 18/1/2017, passed by the Lana JMFC, UPA. It's a UPA only.
Yes, my lord.
Dismissing the miscellaneous application so and so, seeking discharge from GR case number so and so, and the order dated 2017, passed by the Lana Sessions Judge UPA in criminal revision so and so, affirming the order dated 18/1/2017, passed by the Lana JMFC UPA in the miscellaneous application along with all consequences passed by JMFC in the miscellaneous application so and so, along with all consequential proceeding arising out of GR case number so and so, pending before the learned judicial magistrate first class UPA are hereby quashed and set aside. As a result, the learned trial court shall not proceed further with the matter. However, before parting with the record, this court deems it appropriate to observe that the delay in filing the charge sheet appears to have occurred during the course of investigation, which has ultimately resulted in vitiating the prosecution on the ground of limitation. Such delay defeats the very object of timely criminal justice. Accordingly, the Superintendent of Police, Capital Complex, is directed to examine the matter and take appropriate administrative action in accordance with law against the erring officer if lapses or negligence are found, and to ensure that such lapses do not occur in future. Copy of the same also be made available to DGP Arunachal for onward circulation to all superintendents of police of the district in Arunachal Pradesh. I have made some,
Yes, my lord. Yes.
so you have to go through.
Yes, my lord.
Okay.
Absolutely, my lord.
Oblige.
Yes.
Oblige, my lord.
May I please, Lordship? Lordship, I beg to mention item number 12. The standing counsel for RWD department, G. Tarak, has over telephone informed me that he is out of station because of some domestic problem.
Okay.
Item number 12. So, Lordship, here pleadings completed. So, may I humbly pray that matter may be listed on 19 in admission hearing.
Okay. Mr. Lawlen, K. Lawlen, line counsel for the petitioner submitted. Mr. G. Tarak, who appears on behalf of the respondent, requested him for seeking adjournment of the matter for the day to be listed on
19th, Lord.
the ground that he has some personal difficulties today. Stop. Accordingly, as prayed for Kama, list this matter on 19/5.
19/5.
Okay.
And there is an interim order, Lordship.
The interim order passed earlier shall continue till then.
Okay.
My place, my lord.
Yes.
My lord, I beg to mention item number 10, my lord. Here, my lord, I am supposed to file the implement application, but that has not shown for file. So, my lord, I am praying for adjourn for another
Implement.
2 weeks, my lord.
Okay. Mr. C. Modi, land counsel for the petitioner, prays for further. How much time you said?
2 weeks.
2 weeks to file interim.
Implement application,
Okay. Interlocutory application, impleading the necessary parties.
my lord.
Okay. The prayer is allowed. List this matter after 2 weeks.
2 weeks. And in the meantime, my lord, earlier interim may be continued.
The interim order passed earlier shall continue till the next date of listing.
Oblige.
Wait, please, Lordship. Lordship, I beg to mention item
My lord,
number
I pray
8.
for the respondents hearing. Can I pray this be taken up on? Am I audible, Your Lordship? I appear for
Which
respondents in
case?
item number 10. Item number 10. Just mentioned.
Okay. When?
Oh, 10.
So he has mentioned.
Can it be
When?
on 5th of June? Can it
Mr.
be fixed
Modi?
on 5th of June, my lord?
I-
5th June.
5th of June. Okay. To which Mr. Your good name, please.
Obliged.
No, your good name.
N Barua for IOCL.
Oh,
N.
N. Barua
Barua.
for IOC.
N
No.
Barua.
Barua for IOC has no objection of prayer allowed. List is and as requested. list this matter on 5 June. Okay.
Yes, Lordship.
Obliged.
Lordship, I beg to mention item number 8. With the consent of the petitioner, I am appearing for respondent number 4, 7, and 8 for NSPC. I need some time to file my counter affidavit.
My lord, if I'm not wrong, my lord, it is almost 8 months. I think they have not filed a counter affidavit yet.
Earlier also you appeared, I think, not the first time.
No. This is the third time.
So
Wherever
last,
submit yet
last
to
chance may be given, my lord.
Okay.
4 weeks.
Mr. Case section, Atlantic Council, for the respondent number
4, 7, and 8.
and 8, prays for further 4 weeks' time to file affidavit in opposition. Mr. Sunil, Atlantic Council appearing on behalf of the petitioner has no objection, provided it is a last chance to the respondent. Okay. The prayer is allowed. List this matter. After 4 weeks.
4 weeks, because it is on vetting.
Hmm?
It is a law vetting.
Okay. Okay.
Obliged.
Obliged.
May I, Your Lordship?
Hmm.
Your Lordship, I beg to mention item number 13. I need some more time for filing our counter affidavit.
May I, Your Lordship? Lordship, I'm for the petitioner.
You have objection?
Yes, Your Honor, because they have directed to file affidavit since 18 of March.
18 March.
Yes.
Okay, now
Madam
seeking some more time.
Yes, we have not received the proper paravised comment, Your Lordship.
Okay.
Earlier, we have received one instruction.
Okay, Ms. Pango, Land Government Advocate appearing on behalf of the state respondent submits
Yes,
that although she has received some instruction, however, she is yet to receive the proper parawise comment to enable her to file affidavit in opposition. Therefore, she prays for further. How much time you said?
At
Can-
least
can
2
it be-
weeks, Your Lordship.
Can it be on 1st of June?
Okay, Your Lordship.
Okay,
And-
further 2 weeks time.
And Your Lordship, there is
Further-
an,
If it is the 1st of June, then okay, further time to obtain proper instruction and to file affidavit in opposition. The prayer, Miss,
Margam Basar, Your Lordship.
okay, having not been objected to by Mr. Basar, Miss Basar, is allowed. List is and as requested. List is matter on
1st June.
1st of June.
And Your Lordship, there's an interim that may be
Okay,
continued.
stop. The interim order passed earlier shall continue till then. Okay.
Obliged, Your Lordship.
Much obliged.
Your Lordship,
Yes.
I would like to mention item number 25 and 26.
Item number?
25 and 26.
Okay.
We are still waiting for the instructions, Your Lordship, as to any existing claim in the matter.
Okay, you're for a petitioner.
Yes, Your Lordship.
Okay. Miss,
I'm for the state, Your Lordship.
Miss, your good name, please.
R. Takam, Your Lordship,
Land Council.
for
For the
Tikipangi.
petitioner submits that she is still waiting for the instruction as to whether any rights still exist,
Any claims?
any claims still exist or not in the matter. So therefore, she prays for some more time. Prayer not being objected to by the council appearing on behalf of the respondent is allowed. So list this matter after 3 weeks.
Yes.
Okay.
Oblige, Your Lordship.
May I, Lordship? Lordship, I beg to mention item number 28, Lordship, on behalf of S. Thai, Lordship. Due to some personal inconvenience, he is unable to appear, Lordship. So the matter may be fixed on 14th of May, Lordship. I've also taken the consent from the petitioner.
Your Lordship, 14 may be difficult for me, Your Lordship.
Okay. Then give another date. Any other date?
Next week after 14, Your Lordship.
Is it a fixed matter? It's not a fixed matter.
Yes, Your Lordship, not a fixed
Okay,
matter.
Miss. Yeah.
M. Bori, Lordship.
Hmm?
M. Bori, on behalf of S. Thai.
On behalf of,
S. Thai.
okay, Lana Council submits that Mr. S. Lana Council appearing for the respondent has some personal difficulties, therefore pray for adjournment of the matter, which Mr. Ram, Lana Council for the petitioner has no objection. prayer allowed. When?
20, Your Lordship.
20.
Yes.
Okay. As requested by both the Land Council for the parties, list this matter again on 20 May. Okay.
Obliged.
Obliged.
May I please, Your Lordship, I beg to mention for listing of unlisted matters on Monday. Your Lordship.
Okay.
If the matter
Okay.
pertains to the disease order of fixing the weekly market on Saturday. Your Lordship. There is a stay here.
Okay. Weekly mark, huh?
There is a stay operating, Your Lordship.
Okay.
These matters. And in the similarly situated matter, Your Lordship had set aside the disease order itself, Your Lordship, for
Okay.
press re-examination.
Okay. So you want those matters to be listed, or this is new?
This all are they have already been the order has already been stayed in the this matter.
Okay.
So
Okay.
on
Okay.
Monday.
Okay.
Lordship, I beg to mention item number 11, 16, 17, and 23 on behalf of Standing Council, Tapatago.
Eleven.
Lordship.
And 17.
16, 17,
Okay.
and 23, Lordship. We have the consent of the other part.
You are for?
Tapatago, Standing Council for health in item number 11 and for education in rest of the item.
Okay. Let us take up one by one. 11.
11.
11 you are for?
Tabatagum, Standing Council for the health.
Is for respondent.
Yes.
Okay. You have taken consent from the petitioner.
Yes, Lordship.
Mr. Damo.
I'm
No
for a-
objection.
I'm for the petitioner.
Okay.
Here, Lordship, I beg to inform that, and since now almost 6 months lapsed, yet they have not yet filed an affidavit in opposition.
Not yet filed.
Yes.
Lordship,
Hmm.
in item number 11, I'm representing respondent number 5, APPSC.
Hmm.
I have not been furnished with extra copies, so we are seeking some more time.
Okay. Then in that case, you
Extra
furnish
copy.
extra copy
Oh, like that.
to the APPFC. Not yet filed. Not yet furnished. Okay. Mr. D. Boje, Land Council for the petitioner.
3 weeks. Correct?
Mr.
3 weeks.
LT Council.
Land Council appearing on behalf of Mr. T. Togum, Land Standing Council for Education Department.
Health.
Oh, health. Praise for. They have also not yet filed. Praise for further time to file affidavit in opposition. Stop. Miss Anju, Land Council appearing on behalf of Land Standing Council for APPSC. Submits that she has not yet been furnished with a copy of the writ petition. Stop. Mr. D. Boje, Land Council for the petitioner shall furnish a copy of the writ petition to Ms. Anju within 3 days from today. Okay.
All right.
Stop. Is prayed for by the Land Council for the respondent. List this matter after
3 weeks.
3 weeks. Okay.
All right.
Item number 16, 17, and 23, Lordship.
Just a minute. 16. In 16, you are for
Tabatagum, Standing
Tabatagum again. And then
17.
for the petitioner, have you informed?
Yes, Lordship.
Okay, Mr. So-and-so, Land Council appearing on behalf of Mr. T. Togum, Land Standing Council Education Department, with the consent of Land Council for the petitioner. Prays for listing this matter after 3 weeks. The prayer is allowed. List this matter after 3 weeks. And in 17, you are for? Same.
Same.
They are also informed. Similar order. 16 and 17, similar order.
And 23, Lordship.
23? 23 is for what for? It has been listed?
Orders.
Hmm?
Orders listed.
Orders, but then what?
We are yet to file affidavit here.
They have not yet filed.
Yes, I am for the petitioner. It's a small matter and matter may be disposed of on the next date.
Okay.
Service matter.
So they don't have to file any affidavit,
That's why because on 2 occasions they've already sought time,
not yet filed.
not yet filed.
Okay. Mr. So, Learning Council appearing on behalf of Mr. T. Tagum, Learning Standing Council for Education Department. Pray for further 3 weeks time to file affidavit in opposition. To which Mr. Kamal Saxena has no objection. Prayer allowed. List this matter after 3 weeks. Okay.
Published.
Lordship, I'd like to mention item number 18, Your Lordship. Lordship, I've taken the consent of the petitioner. Can it be after a week, Your
Item?
Lordship? After 18, item 18.
It's in order. You are seeking some more time
Yes, Your Lordship.
for filing affidavit.
We have already filed affidavit. Your
Already
Lordship.
filed. Then
Yes. And I want to adjourn this matter for today, Your Lordship. After a week, Your Lordship. Can it be after a week,
after a week.
Lordship?
If you have filed, then can it be listed for admission?
Lordship,
Okay. There is only a state is the only respondent here.
private respondents are also there, Lord.
Private respondents are also there. Whether you have taken steps upon the private respondent,
Yes, Lordship.
are they appearing?
No,
Have they, whether they have already appeared?
yes,
Not yet.
last time appearing.
Wait, I will grant adjournment. Wait for some time. Okay, let us see what's the position. Are you going anywhere?
Lordship,
I've heard you and you
Lordship.
sought for adjournment. We'll
Lordship.
grant, but then let us see the order. And last office note and pass order. Okay.
Lordship. Lordship, item number 21, Your Lordship.
I have recorded Basar sought for
Lordship.
adjournment. Okay.
Oblige, Lordship. Now, item 21, Your Lordship, I'm mentioning on behalf of Estapin, Your Lordship. It's a contempt matter. Lordship may take up this matter after a week, Your Lordship.
Okay, then pass in 18 also, Mr. Sibo. Come, huh? Ms. Basar, Learning Council, Learning State Council, Learning Government Advocate for the State Respondent. Praise for adjournment of the matter for how much? 1 week? 2?
After a week, after 2 weeks, Lordship.
After 2 weeks, to which Mr. Sibo, Learning Council for the petitioner has no objection. Prayer allowed. List this matter after 2 weeks. Okay. And in 21.
I'm seeking for 21, Your Lordship.
Okay, 21. Have you informed the petitioner?
Yes, Your Lordship.
Okay, Mr. Basar appearing on behalf of Mr. Estapin, Learning Council for the respondent with the consent of the Learning Council for the petitioner. Praise for adjournment of the matter for 2 weeks. 1 week, 2 weeks.
After 2 weeks.
2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Oblige, Lord.
Item number 4.
My Lordship. Lordship, this petitioner has been retired on 12/2025. Despite that, I am not granting this my pension benefit, Lordship, without any valid ground. Lordship, may I come to the page number 17?
Okay.
Petitioner is now this ex-serviceman, Lordship. Page number 19, serial number 25, Anil Kumar Singh, Lordship.
Yes.
This is that reflecting his date of the appointment in government servant, 28/12/1994. And Lordship, next is
It's date of confirmation only,
Lordship,
not
however,
the appointment.
Lordship,
Sorry, date of confirmation.
Yes.
Okay.
Lordship, may I read?
Yes.
As per the recommendation of the DPC Health and
Okay.
Science,
Okay.
Lordship, this is
So in 2014,
19.
his service,
Lordship.
this order was passed on. When?
Lordship, 18 February
18
2014.
to 14 only.
Yes,
Okay.
Lordship, giving this retrospective effect, Lordship.
It's okay, retrospective. This retrospective effect. A retrospective effect is for confirmation. Confirm with retrospective effect.
Lordship.
Okay.
And Lordship, now next is order for the retirement from the service, 31/12/2025, Lordship.
Page.
It's phase number 19.
Page 19.
Lordship, it's been 5 going to be 5 months that I am not.
Okay.
And then, Lordship, without any valid reason, Lordship, impugn this communication letter is 20 and 21, Lordship.
In 20, they have made some observation. What is the difference between, so you claim for that you are entitled for all the retirement benefits since 1994?
Yes, exactly, Lordship. And moreover, Lordship, I have been given this all my leave encashment and gratuity. Every is regulated from the 1994. This has been already initiated from the audit and pension, Lordship. Now, after
You have been getting since 1994?
Yes, Lordship. Lordship, 1994. And this pension, IPS.
Only they are asking for some document from you.
No, Lordship, because of
from
this.
the department, I think.
No, Lordship, because of this impugn order, they are not regulating my now this pension beneficiary. And this is, it's been 5 months without any action, Lordship. There is no any response now.
I think it's this matter is to be dealt with by the department. Only department has to come clarify, because this by this letter it says that confirmation is not a mode of appointment. So if properly, according to this letter, probably wrongly it was the wrongly benefit was given, because it was only the confirmation of his service with retrospective effect.
Lordship, may I see the page number 25, wherein this audit and pension contradict this impugn order, Lordship.
Page
number 25.
What is that?
Lordship, 25, during the IPS checking of the Lordship, page number 25, 5, Series A casing. Appointment as a WC loader operator with effect from so and so, and fair regulated up to so and so 2013. Service under ad period regularis from the 1994, Lordship. And accordingly, fare and allowance has been regulated with effect from 1994, Lordship. This is a statement of the same office. 1994, Lordship. And now, Lordship, if this impugn order is continued, it leads.
Here also, see, only because information given by the department saying that this was done since 94, okay? And accordingly, pay and allowances had been re-regulated so and so by the department. Then what this department says, the present, who is this? Audit officer, okay?
No, sir.
In this connection, read entire.
No, sir. In this
The copies of appointment orders from time to time during the service of ad hoc periods from 94 to 99 may be furnished for verification.
And Lord,
have you furnished?
Lordship, by doing so, they have been regulated my this every this.
See, here also it appears that they are only seeking for some documents clarification only. And
also,
these documents has to be furnished.
And so, Lordship, I have made.
It's only the department who is to clarify.
Exactly. So I have met this department party, Lordship.
Have you approached the department?
And because of their miscommunication, Lordship, I am getting difficulties, Lordship.
No. So instead of approaching the department first, why you have come here? Have you approached the department?
Exactly, Lordship. Both sides, Lordship. I have approached.
Where?
Lordship, in fact, this has not been this. Lordship, this any kind of this written this representation is not made before the in fact department. But Lordship,
see, that is where it's a department. The question of department only, because he is asking the documents mentioned here. He is asking for all those for clarification, because law or rules cannot be skipped. Probably as per rules, and that document was not provided. Now asking from the department. Yes. So.
Lordship, at least notice maybe, Lordship.
You obtain instruction or what? What do we do? Is it notice?
Yes.
Okay. Because you have passed order. The department.
audit and pension have written to the executive
Yeah,
engineer, power,
that is right.
head of power department.
So it's a hydropower department is to
Asking
furnish all
for some
those.
queries also, then
This is to be clarified.
clarified, and then they have also
This is to be
said that,
clarified.
the
And also
pension-
furnish certain documents from the department.
not only that, they have also said that, Lordship, since it was only a confirmation, he cannot be given regulation,
But you have given,
regularized.
but it appears that you have already given.
1994.
So you have to clarify if given on what basis.
Yes,
It is the
Distribution.
department who is to clarify. And then
Distribution.
because if you have given, the right accrued to him.
yes.
Hmm.
Lordship, notice may be issued.
Okay.
Let's see.
Okay, hard Mr. G. Kato, Land Council for the petitioner. What is there to be challenged? This only says that books and required pension papers may be resubmitted to this office. What is your prayer?
Lordship, my prayer is for direction of releasing the pension, Lordship, because they are pending.
No,
Despite my
see, this is the clarification is pending.
and Lordship, in fact, this is because of this impune order, they are not releasing the Lordship.
Hey, this one, they have asked to re-regulate the pay of the petitioner to the department.
Then Lordship, as per observation, if re-regulation is done, it will be from the 1994, 1999, as per the audit and pension. Whereas they are same office who regulated my other this benefit.
Let the department communicate that by earlier this communication, this was done.
This is the only notice maybe.
Lordship, in fact, definitely.
The grievance of the petitioner is that due to the communication dated 9/2/2026 issued by the respondent number 2, he has not been paid his pensionary benefits. And then therefore pray for and therefore by filing this writ petition, prays for. You are praying for setting aside this letter also.
Lordship, Lordship, it lead to this recovery of my receipt amount also, Lordship. Subsequent this development, Lordship, because I have been able other beneficiary like leave encashment from 1994, Lordship. If this continues and extend, then there will be recovery from my receipt amount, Lordship. Whereas I am already retired.
Setting aside and prays for setting aside and quashing of the said letter dated 23 dated 9/2/2026 and 23/3/2026. Issued by the respondent number 3. Staff and para, issue notice. Returnable by 4 weeks. Since Miss Giete, landed additional government advocate, appeared and received notice on behalf of
All the
the respondent
respondents,
number.
all the respondents.
Okay, all the respondents. All the state respondents, no formal notice need be issued. However, the petitioner shall furnish extra requisite extra copy to her during the course of the day. Staff, para, please this matter after 4 weeks.
Lordship, since
Obliged.
this matter is for the pension, Lordship, maybe after 2 weeks, Lordship.
After 3 weeks.
3 weeks, Lordship.
Okay.
Lordship, 4 weeks. But,
3 weeks fine is near only.
reply has to come from both the department, from the audit also and from the, from his department also.
Lordship,
Let
pension
it come
paper-
after 3 weeks. You just give the
pension
status
paper
on
we
that
give
day.
like this, Lordship.
Okay. And thereafter also probably you will be seeking some more time to file affidavit. Okay. But at the it's better that you obtain instruction and to file affidavit in this case because it's a pension matter, not yet been released. It will be very difficult for him. Okay.
Obliged.
Like,
Item number 5.
My lord, I may allow to withdraw this petition, my lord, and liberty to file a fresh suit, my lord.
Why?
And I have not the necessary party to the complaint, my lord.
Okay. Okay, okay. You want to implead the complainant?
Yes, my lord.
Is it necessary?
Yes, my lord.
Okay. They are taking a step to appoint the complainant's wife.
Yes, my lord.
No, my lord, it's similar. His pleading is that, my lord, the action of our department is initiated on the complaint of this complainant, my lord. So he will be necessary party. Wrongly or rightly, my lord.
He is a necessary party.
But I believe, my lord, because all action, our action of our department,
Okay,
is based on the
complaint lodged by the okay.
father-in-law of the
But
petitioner.
whether in written, whether she has been communicated that you should discontinue? No.
There is not discontinuation order, my lord. Only salary has been withheld, my lord.
He is a poor fellow.
Yes, my lord.
And then only ensure that she pays the
2 child, my lord.
pays the maintenance for 2 child and then release her. And then she's attending the duty, but then probably not recording.
Not
And then this with the instruction also that can be actually.
Yes.
Okay. Mr.
My lord.
Nanak counsel for the petitioner wants to withdraw this writ petition. Praise for allowing him to withdraw this writ petition with liberty to file afresh after impleading the necessary party stuff. The prayer is allowed. This writ petition is dismissed on withdrawal with liberty as prayed for. Okay. Bless.
Item number 6.
May it please, your lordship.
Yes.
Lordship, in this case, the petitioners have challenged the order dated 4/7/2025 passed by the Deputy Commissioner Lohit District, my lord. Item number 6, my lord.
Item 6.
My lord. The petitioners are challenging the order passed by the Deputy Commissioner, my lord, whereby their right to compensation on land acquisition under the Act of 2013 have been denied on the ground that the land does not fall under the land fall under the reserve forest area, my lord. But the land does not fall under the reserve forest because there is a notification of the year 1977. The process was initiated process was initiated under Section 5 of the AFR, my lord. But subsequently, that notification has not been taken over or any process further has been initiated for conversion of this land to the AF as per the AFR, my lord. And till date, no process has been initiated, my lord. My lord, similar type of cases have been filed by the petitioner, some of the petitioners, my lord. And order has been passed by this honorable court, that is next in page number 126, my lord. You'll find it on page number 126. Some of the petitioners have filed, my lords, where the issues are same, my lord. The relevant portion will find, you also will find at page number 168 or one, yes, 168. 168, Lordship may directly come to 169. Para number 5. May I read, my lord?
Yes.
Oh, no, I'm sorry, my lord. Lordship may come to page number. There's a list of petitioners, my lord. So, page number 169. Yes, my lord. Para number 5. The whole exercise is to be completed by the respondent authorities. There is a direction from the honorable court to make a survey, my lord. And the para number 5 is the relevant portion, my lord. The whole exercise is to be completed by the respondent authorities to committee within a period of 30 days from the date of receipt of the certified copy of the instant order. A copy of the certified copy of the order shall be furnished to the respondent number 5 at the earliest by the petitioners on receipt of such certified copy until the submission of the report of the committee before this court. The construction work related to Huliang, package number so and so, the frontier highway shall remain stayed or until further orders from this honorable court. Yep. My lord, notice has been issued in this case and the process of construction of the road has been stayed, my lord, by this honorable court. And the petition has been pending, my lord, before this honorable court, my lord.
The construction has been stayed.
Yes, my lord, construction has been stayed through this order, my lord. Because the notification.
Whether the construction started?
My lord, as per my instruction, construction. Construction has been started as per my instruction, my lord, but because of this order, it has been stayed, my lord.
Okay.
There are similar two writ petitions, my lord. That is, the first one is WPC 576 of 2025. 576 of 2025. And the other is WPC 79 of 2026. I have annexed the
similar order.
Yes, my lord.
Similar order was passed. Similar order was passed in both the writ petition.
No, in the second writ petition, only notice was issued mentioning about the writ petition in which stay was passed, my lord. Then notice was issued, my lord. That is writ petition 79 of 2006. It is the second writ petition, Your Honor, Your Lordship. But the main writ petition I have annexed. I have read the relevant portion right just now, my lord. It's the same package and the same, the petitioners are from the same district in which the notification has been, the order has been passed by the Deputy Commissioner, my lord, regarding the same package, my lord. The same type of clan, my lord.
Yes.
May I clarify, my lord?
Yes, yes.
My lord has seen the WPC 576, which has the order which they have annexed. There, in today's item number 24, this is the second writ petition. That is writ petition 79 of 26. Suraj time. This is also listed today. And one more writ petition is there. Khodelum Tayang. All these three, and including this present one, now 4 writ petitions. These also, all these 4 writ petitions, including the present writ petition, these all pertains to the Delhi proposed reserve forest. And in the first writ petition, which they have annexed, this Honorable Court has stayed the construction as well as directed that the proper survey has to be carried out. Now we have filed in the first WPC 576, we have filed an IA, which is going to be listed on 11th, next Monday. In that IA, we are praying that for the modification of that order, not for vacating that order, but for modification of that order, because my lord has seen that this proposed reserve forest, the Delhi reserve forest, the proposal to convert it to a reserve forest was initiated right way back in 1977 under the Assam Forest Regulation. Section 5 notification was issued. That is the preliminary notification. Thereafter, Section 6 notification for proclamation was issued.
So now here, we'll issue notice, we file affidavit.
My lord, may I pray that this matter also, if this can, since the other matters is going to be, is fixed on 11th, next Monday, for hearing of the IA. And this, today's item 24, along with this also be listed on Monday, 11th.
Okay.
For passing of appropriate, because it will cover all the other writ petitions also.
Whether there is a stay in the second writ petition.
There is.
Second is 171, any stay?
Yes, 171. Here also, saying similar type of direction has been given, that the construction should not be carried out without proper survey and without initiating the acquisition proceedings.
So without issuing any notice,
yes,
your pray is that it should be listed along with those 2 items.
Notice can be issued and extra copies
together, my lord. So that it listed, we'll just issue notice.
Notice can be issued and extra copies may be served.
Okay.
And this matter also be taken along with the other matters and be listed on Monday.
Hard, Mr.
P. Bora, my lord. P.
Learned
Bora.
counsel for the petitioner. P. Bora, learned counsel for the petitioner. Also had Mr. N. Ratan, learned additional IG for the state respondent number. All.
One, two, 5.
1,
1, 2, 3, 4, and 5.
Okay. 1, 2, 5. And Mr.
6.
Katoha, and DSG for respondent number 6, 7.
6 only.
6. Okay. So. So 7 is NHCI DCL has some standing counsel separate. Okay.
No standing counsel. They appoint their own counsel.
in the earlier cases, my lord, Mr. R.B. Yadav appeared for the, that's it, respond number 7.
Okay, and it's 7, okay.
Yes.
My lord may simply issue notice for today. And
This is only, according to him, that it was only in 1977, it was only a proposal,
Proposal, my
not
lord.
yet been finalized.
yes.
Finalized.
So on the basis of that,
Section 17
this
notice has been not been published, my lord. Section 17 for finalization of the area under Reserve Forest Act, my lord, that has not been finalized till date, my lord, as per DFA.
Section 5 notification, preliminary notification was issued, saying that this area is going to be a reserve forest.
Where is the impugn order? Impugn order is at?
Impugn order is at page number, my lord,
Okay.
44, my lord, 44.
My lord, the main issue here will be whether these petitioners will be entitled to claim compensation either under the Assam Forest regulation, if acquired, or under the LARA.
So admittedly, it was not finally declared as a reserve
forest.
Okay.
But in between, there is an proclamation notification under section 6. That proclamation notification under section 6 of the Assam Forest Regulation. What it says that if they have annexed the Assam Forest Regulation also. If my lord comes to page 53.
Mm-hmm. 53.
My lord, I'll just place my this Assam Forest Regulation, Volume 1. Section 7. I'm sorry, not section 6, section 7. My lord will see the forest regulation, Assam Forest Regulation. It starts from page
5.
Page 5. Then page 9, section 7. May I read, my lord?
Yes, sir.
7.1. During the interval between the publication of the proclamation and the date fixed by the notification declaring the forest to be reserved as hereinafter provided, no rights shall be acquired in or over the land comprised in such notification except by succession or under a grant or contract in writing made or entered into by or on behalf of the government or some person in whom such right or power to create such right was vested when the proclamation was published. And on such land, no new houses shall be built or plantation formed, no fresh clearings for cultivation or for any other purpose shall be made, and no trees shall be cut for the purpose of trade or manufacture except as herein provided. But what happened? Section 5 notification, initial notification was there. Then section 6 notification for proclamation. Then now after the section 6 notification for proclamation that was issued in 1978.
1978?
Yes. 77 was the 1977, I'm sorry, Mal. First notification, preliminary notification under section 5 is 1977.
Yes.
Then the proclamation order is at page 70. I know this is first it is 1978, 8 August 1970, proclamation order. Although they have missed out in the type copy, it says, if we see the original one, it says 8 August 1978 at page 68, 69. This is the proclamation notification under section 6.
So the final, it attained finality after issuance of
Section 17.
Section 17.
Yes. Now, still, although, my lord, I'll make my respectful submission, although there has been considerable delay, right from 77 till that, after issuance of the proclamation notification under section 6, till that section 17 has not been issued. But even then, this process has not been abandoned till now. So for that reason, the Forest Department, they wants to complete the process. Those who had rights at that point of time, prior to the notice for proclamation, they will be entitled.
Okay.
So that process under the Assam Forest Regulation, that may be allowed to be completed. That will be our submission. So this matter may be taken up on
We'll just
Monday.
issue notice.
Yes.
Okay.
Yes.
So I'll just briefly mention it is submitted, the grievance of the petitioner is that the respondent who issued the DC is respondent number
Respondent number 3.
Issued the imperial order dated 5/9/2025 treating the proposed reserve forest notification of notification issued on this proposed was issued on when?
Proposed reserve forest.
Yes.
13/12/1977. 13/12/1977. 13/12/1977.
13/12/1977.
My lord.
Issued the order dated 5/9/2025. No, not 5/12. 4 July. 4/7/2025. Stating that the alignment of frontier highway under Lohit district from kilometer 60 to kilometer 121.500 within bracket length 61.500 kilometer bracket close falls under the Delhi proposed reserve forest, and hence there will not be any acquisition of the said land. It is submitted that the notification under section 5 of the Assam Frontier Regulation.
Forest.
So Assam Forest
Forest
Regulation
Regulation.
18 91. For, what issued on date?
1312.
1312, huh? 1977. However, subsequent mandatory procedure under section mandatory procedure under 7 to 16.
16.
Huh?
7 to
Sorry,
16.
7 to
17.
oh, 7 to 16.
7 to 16.
17.
16.
16 was never undertaken, and no final notification under section 17 was
Yes.
ever issued. Or ever issued, huh? Thus, the notification for declaring reserve forest has not yet attained the finality. Stop, huh? Para. So you are praying for, by filing interlocutory application, you are praying for the vacation of the interim order.
Modification.
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 Modification to what extent?
To the extent because as per the interim order,
But then, okay.
a committee has been directed to be constituted
Uh-huh.
so as to assess a survey and assess the properties of the petitioners
Mhm.
where the road is to be constructed. Our IA is to the effect that as under the Assam Forest regulation, the forest settlement officer, who is the deputy commissioner himself, he will first exercise the powers under the Assam Forest regulation, identifying the persons who are entitled, who were settled there earlier, and then if those persons are identified, then the question of giving compensation will arise. Otherwise, after the declaration, after the proclamation has been made, many persons who were not even entitled to come and reside in that proposed reserve forest, they might also start claiming compensation. That is the thing. Therefore, when section 7 of the Assam Forest Regulation says that no rights will be acquired from the date of proclamation, meaning thereby no third person who were never settled there can acquire rights over that land.
Claim. Okay.
That's why. Otherwise, by this time, many might have encroached into the proposed reserve forest, those who never had any title. For that, at least the exercise under the forest regulation be carried out.
Okay. So then the interim prayer also then on that day?
Yes, interim prayer also on that day, on Monday.
Okay. Issue notice, huh? Since Mr. Okay, so since Mr. Botha and Ratan Dana Addition IG appeared and accepted notice on behalf of the respondent so and so, huh? And Mr. Kato for respondent number 6, no formal notice need be issued. However, the petitioner shall furnish requisite extra copy to the Land Council to the Land Council appearing on behalf of the respondent when are you going?
Well, today only I can
furnish copy
My
within
lord,
2 days.
My lord.
Okay. Stop. List. Okay. It is submitted that the how many analogous matter? There's another 3 analogous matters are pending for this court, huh? Being which one?
576.
576, 25.
25.
25.
Then 79.
9 only 2026.
79.
Of 26.
26.
And 171 of 26.
Okay, 171 to 26. The They may be take along with the present repetition stuff, huh?
Item 24.
Item 24 also, huh? Item 24 is,
I have taken consent from Mr. Patil.
okay. Okay, 79, item 24, okay. And pray for listing this matter together, huh? Okay, let's pray for comma. List this matter when?
Monday, 11.
Monday,
Because the earlier 576 has been already fixed on Monday.
okay. The petition number 576 is fixed on Monday.
11.
This
11th.
11, okay. This matter may also be listed along with on 11, along with the 576 on Monday, huh? Stop. Read aloud, listed accordingly on Monday along with all those. Okay.
Highly obliged.
Deeply obliged.
Highly obliged.
Item number 7.
May I please, my lord?
Yes.
Your lordship, my case is related to an order passed under this no, one caveator was there, my lord, and we have served the notice on him. And
Caveator?
caveat maybe ditchers first, my lord. Caveator appears, my
Okay.
lordship.
Since the caveator is being represented by his land council, who is for the caveator? Mr. Ingo. Okay. Being heard, the caveat stands discharged. Okay.
Before my brother could start with his submission, may I apprise this honorable court the status of the present case. As per the record, lordship, this petition has become infractious. The order which the petitioner has sought to challenge before this honorable court has already been complied.
Okay.
Your lordship. May we submit, my lord?
Already complied means?
Deputy Commissioner, they have complied with the order passed by the learned repress authority on 21/5/2026, lordship.
Deputy Commissioner?
Deputy Commissioner has complied with the order passed by the learned repress authority.
Okay.
Yes.
Money already deposited?
Yes, money already deposited and check has already been issued. Now there remains no issue. However, there is a remedy for the petitioner, your lordship, under the Act, lordship. Section 84 of 82 subclause 2 of the Act. There is a provision, lordship. The petitioner can approach before Deputy Commissioner and file a reference application to recover the amount if amount is wrongly paid. There is a provision. And there is a state amendment in section 33A.
33A of Act.
Yes. In fact, this is a state amendment of Andhra Pradesh.
What it says 33A?
State amendment of Andhra Pradesh might not be applicable to us, my lord.
Okay. And 82 is what provision?
82 is offense and penalties, lordship. Offense and penalties, lordship. 84, not 82, lordship.
What? 84 2?
84 2, lordship. 2013.
When the order was passed, impugned order was passed?
It was passed on 21/4/2026.
21/4?
Yes, 21 April.
Very quick?
Yes, 21 April order was passed to comply.
And then the petition was filed on 20?
Yes, lordship.
Yes.
The petition was filed on 20.
And
now matter
21
was
passed order?
Matter was listed on 21.
Okay, order passed, now released.
Yes, on motion stage, the matter was disposed of.
Okay.
Since the issue was very limited before the reference authority, Lordship.
No idea. Anyway, let him submit.
My lord. Your lordship, since my brother says it has been complied with, we are not there, my lord, whether it has been complied with or not, my lord. Our issue here is not on the merit of his case there, my lord. Our issue is the jurisdictional error that has been
Committed by district. Oh, no,
no,
district judge.
Yes, reference court, my lord. That is the main issue here. And violation of principle of natural justice, my lord. Your lordship.
Now, how you are affected is a question again, ma'am.
My lord, this, I am actually
this is regarding
interested person. I am the interested person here, my lord. One reference petition is already there, was already there. My reference is your...
With regards to the same land?
Yes, my lord, same land. And that was very much in the clear knowledge of the presiding officer also, my lord. May I take your lordship?
Whether it was pending
my
at the
lord,
time of deciding the present one?
Yes, pending, my lord. We have to say it is pending because we were granted liberty to file a press.
But have you filed?
Yes, we have filed, my lord.
When?
It was filed, it was 2nd May, my lord. 2nd of this May, my lord.
May?
Yes, my
But then this was decided in April?
This was decided on April 21, my lord.
Okay, after deciding, after already decided, only you filed?
Yes, my lord, because
how it is pending?
My lord.
How it was pending?
My lord, it was not in our knowledge. We were interested party and we have not been given opportunity of being heard, number one. And basic question here we are raising, your lordship, is the learned this authority, learned presiding officer, without the reference of the competent authority, district collector, my lord, he has passed an award. That is a clear violation of the jurisdiction.
You are claiming over how much of the area?
No, your lordship, actually 16 acres something is there under our reference, my lord.
Okay.
From that 16 acres of reference, my lord, the private respondent number 4 to 6, my lord, they have this purportedly given 4 acres to this private respondent number 3 caveator, my lord. And that fact has also not been proved. Only that was not also no adjudication and no evidence, my lord. Apart from that, my lord, even to take up the issue, my lord, the learned authority, presiding officer, was not having jurisdiction, my lord. May I take your lordship to this to the act, my lord. Page of this section 64, my lord. Section 64 of the act, my lord. Reference to the authority, my lord.
Yes.
Reference to the authority.
It does not come through Deputy Commissioner.
No, my lord. No. No reference come to him to the authority, my lord. Number 164, subsection 1. Any person interested who has not accepted the
subsection
64, section 64.
64, 1.
1, your lordship. Any person interested who has not accepted the award may written application by written application to the collector require the matter be referred by the collector for the determination of the authority as the case may be, whether his objection to be to the measurement of the land, the amount of the compensation, the person to whom it is payable, the right of rehabilitation and resettlement under chapter 5 and 6 of the apportionment of the compensation amongst the person interested, my lord. Any person who is aggrieved should file one application for reference, my lord, to the deputy commissioner, district collector, my lord. That is the provided that the collector shall, within the 30 days from the date of receipt of application, makes a reference to the appropriate authority. And then only within the period of 30 days, my lord, reference is to be made.
That has not been made here.
No, my lord. No, my lord. Further, in case he submits that in his application, he stated that Deputy Commissioner Tato has refused to make any reference. That's why he came forward directly, my lord. In such event, my lord, second proviso is there, my lord. If for his protection. Second provision is there, provided further that where the collector fails to make such references within the period so specified, the applicant may apply to the authority, as the case may be, requesting it to direct the collector to make the reference to it within a period of 30 days, my lord. So, what the caveator should have done, my lord, if the collector fails to make the reference within 30 days from his objection, my lord,
then also he had to approach?
Yes, he should have approached the authority, my lord, requesting the authority to issue a direction to the deputy commissioner to make his reference, my lord. Means, under this section, my lord, reference is compulsory. Apart from that, I would like to substantiate my stand that without reference, this authority cannot make any decision. Another section, please come to this section 69, my lord. Why I am saying that section 69, my lord, without reference, authority cannot make any this award, my lord. Section 69 also supports this, my lord. The scheme is like this, my lord. Section 69, may I read, my lord?
Yes, sir.
In determining the amount of compensation to be awarded for land acquired, including the rehabilitation, resettlement, entitlement, the authority shall take into consideration whether the collector has followed the parameters set out under section 26 to section 30 and the provision under chapter 4 of this act, my lord. Means, without this reference from the deputy commissioner, how the authority will, based on which record, my lord, he will pass this award, my lord, because there is no provision here that award can be passed by the authority on the insistence of the agreed person, my lord. Only insistence is not sufficient, my lord, for an award. It shall have to be passed based on the reference made by the deputy commissioner, my lord. Your lordship, please come to page number section 51. I would like to further section 51, my lord, subsection 2, my lord. I would like to this further substantiate my argument on this point, my lord. Section 51, my lord. Establishment of land acquisition, rehabilitation, and resettlement officer. Subsection 2, my lord.
Just a minute, huh? 51.
51, my lord. Subsection 2, my lord.
Yes.
My lord, subsection 2.
2.
Subsection 2, my lord. Okay. The appropriate government shall also specify in the notification referred to in the subsection 1, it is establishment, my lord, and here, my lord, the areas within which the authority may exercise jurisdiction for entertaining and deciding the reference made to it under section 64 or application made by the applicant under proviso, second proviso to subsection 1 of the section 64, my lord. It also clearly says that even jurisdiction to make award, my lord, to make adjudication has to be specified based on this reference made by the deputy commissioner, my lord. From all these sections, schemes of all these sections, my lord, it is clear, my lord, without reference, there cannot be any award, and it is it is a serious error of jurisdiction, and that learned authority never had the jurisdiction to issue this, my lord. Now, what this caveator has submitted in his application, my lord, he says award was made rejecting my prayer, my lord, by the deputy commissioner, and no reference has been made to the court. That's why he filed an application under section 64, subsection 2, my lord. Whereas under section 60, subsection 2 is not invocable before authority, my lord. 64, subsection 2, my lord. He says this application is filed under subsection 2 of this section 64, my lord. May I take your lordship to section 64, subsection 2, my lord?
Yes, sir.
The application shall state the ground on which objection to award is taken, my lord. This award objection, ground of objection, it should have been filed before the deputy commissioner, my lord, not before this authority. But this caveator filed his petition for reference, my lord, under for an award, my lord, for an award under subsection 2 of section 64, my lord. And accordingly, my lord, this matter was filed on 20th this April, my lord, and without issuing notice, my lord, without issuing notice, number one, to the interested party, and without issuing notice to the deputy commissioner, and without
So
obtaining
notice is to be given, also
my lord,
given to
please,
the
please
deputy
come,
commissioner
please
also.
come to, yes, my lord, please come to page number 66 or section number 66, my lord. Your lordship,
Mhm.
section 66,
Notice.
my lord. If a normal this reference petition is to be adjudicated, my lord, but it is not a normal this reference application, my lord. Nonetheless, process, my lord. Section 66. The authority shall thereupon cause a notice specifying the day on which the authority will proceed to determine the objection and directing their appearance before the authority on that day to be served on the following persons, namely the applicant, means caveator, to all the interested person in the objection, my lord. Now let's come to page number section 3, clause X, my lord. What is the meaning of interested person, my lord? Definition, my lord. Section 3, clause X.
Section
3, my lord. I am interested person. And even deputy commissioner, if the objection
Section
is
3 clause
10, my lord.
10.
Yeah, my lord. My lord. May I read, my lord? Section 3, clause 10. My lord. 10. Interested person, interested, my lord.
6. Eight. Clause 10.
My lord. All
Yes.
person interested means all person claiming an interest in compensation to be made on account of the acquisition of land under this act, my lord. Means that 16, admittedly, my lord, admittedly, that 4 acres of land that he has taken for apportionment of this compensation is a part and parcel of 16 acres, my lord. That I am claiming and I am having this reference there, my lord.
Now, in the earlier reference filed by you,
my lord,
whether you have implemented the private respondent?
No. He was not the party, interested party in the this Kedar, my lord, this list of interested party.
16 acre.
No.
Okay, but this 4 acre comes under 16.
Yes. 4 acre comes under 16.
So according to you, he has no claim.
He has no claim, my lord. He has no claim because in order to claim, my lord, he has to first make a reference, favorable reference from the deputy commissioner, my lord. If the deputy commissioner doesn't give any favorable reference to him, that his option is different again, my lord. That can be appealed before your lordship or in form of this jurisdiction or appeal before this. If there is a malafide, then come before your lordship under section 2, under article 226. And if there is on merit, my lord, factual and fact of law and fact of this a question of law and question of fact, my lord, then he can go to authority, my lord. There are 2 options.
In his reference, whom did he make party?
So he made only deputy commissioner, my lord.
Okay.
And even deputy commissioner
was not issued notice.
No notice, my lord.
Okay.
Nonetheless,
okay. So yes.
And my lord, I am having this also.
Will issue notice?
My lord, we are this claiming for this praying for this interim order also, my lord.
Okay. You have anything, sir?
Yes, Lordship may kindly come to the page number 50 of the petition, Lordship.
Yes. Yes.
Lordship, my brother has repeatedly stating that the reference application 2 of 26 as filed under section 64 subclause 2. No, Lordship, that is not correct. The application is filed under 64 subclause 1, Lordship. Lordship, again, Lordship may kindly come to the page number 79 of petition. Lordship. 79, Lordship.
Yes.
Before 79, may I take Lordship to the page number 75? Lordship, this is the application filed by the father of the present private respondent number 3, Lordship. Now, Lordship, this application has filed on 27 May 2024, Lordship, praying for release of the amount in respect of 4 acres of the land. Now, this application has lain pending before Deputy Commissioner for almost 1 year, Lordship, without hearing, Lordship. So, what Deputy Commissioner ought to have done is that, Lordship, this application has to forward it to the reference authority within 1 month, Lordship. That was not done, Lordship. So, agreed by this, the act of Deputy Commissioner, the private respondent number 3, the caveator has approached.
No, say this 75 was filed by you.
Yes, Lordship.
What is your name?
Tashuk Rinya, Lordship.
He is not in the respondent. Not the respondent. Is he respondent?
No, he has authorized his son to represent, to file the reference application before reference authority.
Okay.
The authorization is also there, Lordship. But this application was laying pending before Deputy Commissioner for so long. So agreed by the act of Deputy Commissioner, the reference application number 03 of 2025 was filed. Lordship, may kindly come to the page number 79. Or 77 is the order. And operative portion is 78, Lordship, last part.
This was earlier.
Yes.
This is also different name.
No, Lordship, same name, Lordship. Kiran Rinya.
Is the respondent number?
3, private respondent name number 3 in this present petition, Lordship.
Okay. So the present impugn order was also passed in Kiran. Okay.
Yes. So, Lordship, page number 78, Lordship.
78.
Last, after, May, Lordship. After hearing the learned counsel and perusing the petition and annexure therein, the application is hereby accepted, and Deputy Commissioner Sriyomi is hereby directed under 64 of LAR Act to dispose of the representation dated 27/5/2024, preferably within a period of 30 days from passing of this order following due process of law, Lordship. This was passed, Lordship. In compliance of this order, Lordship, again, page number 79, Lordship.
79.
In compliance of this order, the Deputy Commissioner has summoned the parties on 9/7/2025, Lordship, wherein these orders were passed, Lordship. My last operative portion is, Lordship, last para, Lordship. May, Lordship.
Yes.
Sri so and so, this is the private respondent number 4 in present petition, Lordship. Sri so and so has stated that he and his 2 brothers, Lordship, private respondent number 4, 5, and 6 in present application, Lordship. His 2 brothers, namely Sri so and so, have gifted the 4 acres of land to Sri so and so, father of so and so. That they have no any complaint regarding a release of the compensation against 4 acres of land in favor of Sri so and so after obtaining clearance from the court case pending before District and Session Judge Ala West Siang District, reference case number 03/2024, Lordship. These orders were passed, Lordship. Only because of pendency of this.
Okay, this order was passed pursuant to compliance of the order dated 22/5/2025 passed by the reference court.
Yes, Lordship.
Who is the Sri Udirinya? Who Who are this person, this name mentioned? Are they?
Primary respondent number 4, 5, and 6, Lords. In present petition, Lords.
Okay. Kiran. Nappe. Rajam. So in your petition, you have also annexed this.
Yes, Lordship. These orders were set aside by order dated 21/4/2026, which the present petition is before this honorable court.
This order was set aside?
Set aside by the learned repress authority.
By the impugn order?
Yes. Now, Lordship, again, now the question
what this order says, let me just, by this order, it was?
By this order, only the issue was that Sri so-and-so, last part, Lordship, pending before district and session judge Alo West.
Wait, you are reading which?
Yes, Lordship, 79 last part, Lordship. My Lordship.
Yes.
Sri so-and-so has stated that he and his two brothers, namely so-and-so, have gifted 4 acres of land to Sri so-and-so. That they have no any complaint regarding the compensation against 4 acres of land in favor of Sri so-and-so. After obtaining clearance from the court case pending before district and session judge Alo West District, reference case number 03 of 2024. Lordship. This was the only reason that the compensation amount was not disbursed to the present petitioner, present caveat laws, respondent number 3. So, again, Lordship, this reference case number 3 of 24 has been withdrawn by the present applicant itself, present petitioner itself, by order that is 16.
So this order was passed in reference number, petition number?
Reference petition number, Lordship, 02/2025, Lordship.
No, this order?
Yes, Lordship. There were 3 reference applications by same applicant. That is.
So this order was withdrawn?
No, Lordship. This
not this one. This petition.
No, Lordship. This was not withdrawn. Lordship, the exact position of the case is that the present petitioner, they have filed one reference application, numbered 03 of 2024, Lordship. Now, Lordship, may kindly come to the page number 81. Hmm. 81 is a type copy, Lordship, and 80 is. No, Lordship, by this order that is 16/9/2024, they have already withdrawn their reference application, 03 of 2024, Lordship. So, there was no any pending reference application before the reference authority, Lordship, during the time of passing this order, Lordship, order dated 9/7/2025. So, this order was wrongly passed by the non-deputy commissioner, Lordship. So, as the present respondent number 3 has challenged this order before, again, learned reference authority.
No, this 16/9/24 it was passed by? Same.
No, that was passed by the in charge of learned reference authority, Pasigat, West Yang in charge.
In reference number?
In reference number 03 of.
Okay, and this reference number 03 was withdrawn?
Yes, Lordship. Withdrawn by.
It was filed by the petitioner. So it withdrawn with liberty.
No, Lordship, there is no any liberty granted, Lordship.
It was a case, there was no reference coming forth from this deputy commissioner. So I made an application under proviso 2, my lord, that I have alleged your lordship, my lord, that direction may be given to them. In due course of time, my lord, they filed they provided the reference, my lord. The moment a reference is placed before the authority, my lord, this case obviously becomes infructuous. Reference has to be tried, my lord. After filing of this, my lord, my reference is posted in my petition, my lord. My reference petition, after filing of this, my initiation of this hearing, my lord, reference was submitted by this deputy commissioner. That's why I had to, here also it is clear, my lord. During the course of hearing, it is informed that the learned counsel correspondent with the DC has already referred the matter to this court by reference to dated 13/8/2024, my lord. I have mentioned here, my lord. That's why this question already instructions and trial of the reference letter 13/8/2024 is still pending, my lord, and it was going on, my lord.
No, Lordship, my brother is something confused.
No.
With regard to the order dated 9/7/2025, Lordship. Now, by this order, I was aggrieved only because that the reference case number 03/2024 is pending before the reference authority. However, by that time, that reference case 03/2024 has already been withdrawn, Lordship. So this order was passed without there being a reference application being pending, Lordship. So my contention before the reference
But
authority.
no notice was issued to the, even to the
Lordship,
commissioner.
Lordship, the reference authority has inherent power under section 60 subclause 3.
To forego the notice.
Yes.
No, my lord. That will be serious misinterpretation of law, my lord.
My Lordship.
60?
60 subclause 3, Lordship.
So lay down the CPC.
Last sentence, Lordship. The authority shall have the power to regulate its own procedure, Lordship. So my reference application was filed under section 60. Page number 50.
So according to you, this subclause 3 of 60 permits the reference court to forego the notice.
No, Lordship, in this case, Lordship, notice was not at all required, Lordship. Because, Lordship, again, on that point of argument, Lordship, I would say that this application, the present petition itself is not maintainable, Lordship. Because
why?
I will come, Lordship. I am satisfied, Lordship. Lordship may kindly come to the page number 20. And type copy is at page number 26, Lordship. Serial number 658, Lordship.
$58,
Lordship. Here, the name of private respondent number 4, 5, and 6 are clearly reflected. This is the part of award, I think, Lordship, that they have annexed, Lordship. Here, Lordship, the only the name of private respondent is reflected. The question of this present applicant, present petitioner, does that arise, Lordship? Since their name is not reflected in the award, how they can file without challenge this award letter, Lordship? to establish their rights and ownership and their locus, their name has to be reflected in serial number 58, Lordship. Because these 3 persons have gifted 4 acres of land to the father of present caveator, Lordship, the private respondent number 3, Lordship. This is the only question. The dispute is within these 3 and the private respondent number 3, Lordship. Even if notice is required, I need to send notice only to these 3 persons, Lordship, along with Deputy Commissioner, not to the present petitioner. So therefore, Lordship, even this petition is not maintainable before this order in present form, Lordship. Before now, they are not an interested party as per serial number 58. And how this order dated 21/4/2026 is prejudiced to them, Lordship, is if at all the order is to be challenged, that has to be challenged by these 3 persons, Lordship, if they are agreed by the order dated 21/4/2026. But they are before this honorable court as a private respondent 4, 5, and 6.
By the way, where is your name in this list? Petitioner's name?
My lord, my name is not specifically here, my lord, but there has been this agreement between the parties for which reference was going on, my lord.
Agreement between the parties?
Between this, please come to page number 6, my lord, of my petition, my lord, para 3, my lord. Para 3, my lord. Of my petition, my lord.
Page?
Page 6, my lord. Page 6. Para 3, my lord. We knew, my lord, this question might come. That's why we have depicted this diagram, my lord. Our forefather was Muktum Rinya, my lord. And we all are ancestors, descendants of same ancestor, my lord. Now, here, last Tumru Rinya, right side, my lord. Tumru Rinya's son was Rudu Rinya. Rudu Rinya's 2 sons, Bore Rinya and Taru Rinya. And here, middle, my lord, Tumjam Rinya and Tasuk Rinya, Udur, their son is the private respondent, my lord, 3 private respondents. After this, my lord, there was this agreement between the 2, my lord, between these 2 family, my lord, because that was an ancestral, undivided ancestral property, my lord. That question was there, and regarding this only, my lord, reference was forwarded to the authority, my lord. That reference was forwarded, my lord. My lord, reference is at page number 27, my lord. Page number 27. This is the forwarding of the reference, my lord. So this application was, our application was forwarded to this presiding officer, my lord, authority, my lord. That authority was, my lord, it was taken up, my lord, in 2024, my lord. And that application was taken up in 2024, my lord. And it is in page number 2B, my lord. My lord, 2B. Page number 28, my lord. Annexer 2B, my lord. My lord. 28, my lord. Please come to the page. We have the applicant here, my lord. And please come to page number 30, my lord. I am the petitioner number 2 here, my lord. Applicant number 2, page number 30, my lord. Bore Rinya, my lord. Now let's go to the. We were air, my lord. This question will come, my lord. Your lordship, the fate of this was petition was, my lord, it is posted in page number 47, my lord. My lord, page number 47. It was also, but we cannot raise this question here, my lord. It was not at all a matter to be dismissed, my lord. But there also, she has committed a very serious error of law, my lord. May I read this?
So this
order?
petition is different.
No, my lord. It is the one, my lord. It is the one we were asked to withdraw, my lord. By this. And order is page number 47.
The latest one is 03. This is 05.
My lord. Page number.
This 5 was withdrawn.
My lord. Page number 47, my lord.
Just a minute.
This 5 is my lifeline, my lord. We knew if this petition is not annexed before your lordship will never entertain our writ petition under 226. Questioning on this point only, my lord. Please come to page number 47, my lord. May I read? Why I am saying our issue is subsisting, my lord. Page 47, my lord. Annexure 2C, my lord. Sri Tajit Tajom, the learned counsel for the petition applicant, Sri Dojom Momdir, the learned counsel for the respondent number 2 and 3, Sri Noppe Rinya and Sri Tajam Rinya and Sri Kembom Bagra, the learned counsel for respondent number 4 are present. While hearing the learned counsel for the respondents, it is found while perusing the case that the learned counsel has not invoked any provision of law on the act under which he has sought for the relief. On being pointed out the defect in the reference case, the learned counsel for the applicant has prayed to be allowed to withdraw the same with liberty to file a press on which the learned counsel for the respondent have raised no objection. In the premises aforesaid, the reference case is then dismissed on being withdrawn with liberty to file a press, my lord. Please come to this. With liberty to file a press, and this order was passed on 7 April, my lord. 7 April, and at least before expiry of 30 days, my lord, I filed it, my lord. Even before expiring of 30 days, my lord, my repiling slip is next, my lord, page number 49, my lord. Page number 49. I have filed it, my lord, and it is listed at suite number 0326, my lord, page number 49. Reference case number 03, and it is pending consideration, my lord. Now, my lord, I would like to clear one thing, my lord, and I am grateful to my brother for this repressing me with this forgotten section, my lord. Actually, it should have been me who should make this submission before your lordship, my lord. Section 3 or section 60, subsection 3, harped upon by my learned brother, my lord. Rather, it does not exempt the authority from causing any notice, my lord. Rather, it contemplates, my lord. Not contemplate, my lord. It mandates, my lord. Please come to, may I read, my lord? Subsection 3.
Of?
Subsection 3 clearly mandates.
Subsection 3 of?
Section 60. That my brother was just relying on, my lord. It should have been, in fact, relied upon by me. But I am very grateful to him for repressing me with this forgotten section, my lord. Subsection 3, my lord. May I read? The authority shall not be bound by the procedure laid down in the Civil Code of Procedure, but, my lord, shall be guided by the principle of natural justice, my lord. It is clear. The authority has been mandated under this section also, subsection also, to follow the principle of natural justice, my lord, that he has not done. And there is no probability for maintaining following this, my lord. Please come to the, come to page number. My lord, come to page number 68.
Of the petition.
Petition, my petition, annexure. Page number 68, my lord. It is the petition affidavit sworn by the private respondent, this caveator, my lord. Caveator has sworn this affidavit, my lord. May I read?
Page
68, my lord.
68.
My lord. My lord, and 69. It is the affidavit. Now, 69 clearly shows that, my lord, and I signed this affidavit on 20th day of April 2026 at court premises, Alo. Means On 20th April 26, he has sworn it. Obviously might have filed it after that. Next day, my lord, in the extraordinary haste, my lord, this impugn order has been passed, my lord. Means all the documents that he has annexed here was also not proven. This learned presiding officer acted upon unproven this secondary evidence, my lord. And in an extraordinary haste, my lord, he has issued this without issuing notice number 1, my lord. Clear violation of this principle of natural justice, my lord. And second leg of argument, prime leg of argument is that when there was no scrupulous adherence of section 64, my lord, reference, my lord, she cannot award any substance, my lord, make any award, my lord. Award shall have to be based on the reference made by the Deputy Commissioner, my lord. Please, my lord.
Anyway, so what we'll do, we'll issue notice at the moment. The entire matter will be taken up hard.
My lord, your lordship, if because it is a question of this, the private response, this caveator is also not in position, clearly not in position to show that reference was made. And in absence of reference, an order passed.
Where is the impugn order?
Impugn order is at page number 87, my lord, or 85, my lord. So this order has been passed without any reference from this Deputy Commissioner, my lord. So obviously, when an order is passed without reference, that is beyond jurisdiction, my lord. And an order passed beyond jurisdiction cannot be allowed to sustain, my lord.
Hard, mister. Jammu, huh? The Jammu Land Council for the petitioner. Also hard, Mr. Ingo, huh? No, who is our state is also respondent. Okay. And Luang Lines, government advocate, huh? For the respondent number? One and two. And Mr. Ingo for appearing on behalf of the respondent number 3. Staff on pair. This writ petition. The present petition under Article 226 and 227 of the Constitution has been filed by the petitioner challenging the legality, propriety, and jurisdictional validity of the order dated 21/4/2026 passed by the learned presiding officer cum district and sessions judge Alo in reference case number 2/2026. Under the provision of the right to fair compensation and transparency in land acquisition, rehabilitation, and settlement Act 2013. Stop, huh? It is submitted that earlier, the petitioner Are the reference proceeding regarding apportionment filed by the petitioner. Was withdrawn with liberty. Where was that order granting liberty to you?
Your Lordship, page 47, my lord. Page 47, my lord. It was on 7/4/2026, my lord.
Okay. Reference, write the number also. Huh? Case number 05/2027 filed by the petitioner was withdrawn on 7/4/2026 with liberty granted to the petitioner to file afresh. And thereafter, the petitioner filed. Well, the latest one is, yours is numbered as?
Number is, my lord, 3/2026, my lord. Page number 49, my lord.
And person to liberty granted. The petitioner subsequently filed press reference petition number which was registered as reference case number 03/2026 before the same authority. Staff, however.
And your lordship, very interestingly, my lord, this fact has been reflected in the impugn order also. It clearly shows that presiding officer was very much in the knowledge of this fact, my lord. It was reflected, it has been reflected here, my lord. In the impugn order also, this liberty. Because he was the only authority that granted me the liberty.
During the intervening period, the impugn order was passed in favor of the respondent number 3.
My lord, on the insistence of private respondent number 3. Without any
this impugn order is passed in favor of respondent number
3, my lord.
3.
Private respondent number 3, my lord.
Okay.
Caveator.
Who is neither recorded claimant nor beneficiary in the acquisition record. And by an order dated, by an impugn order dated 24/2026. The petition filed by the respondent number 3 was allowed. And the district collector, Xiaomi district, has been directed to pay the awarded amount to the petitioner with all the consequential entitlement is entitled under section 71 and 80 of LARR Act 2013. Further directed to deposit the awarded amount with all other consequential entitlement into the account of the said court within the period of 7 days from the date of the order. It is submitted that the reference application was filed by the respondent on 24/2026, and immediately on the next day, that is on 21/4/2026, the said impugn order was passed, and no any notice was notice to the petitioner were issued, nor petitioners, were issued, nor or even to the deputy commissioner concerned. Staff, para issue notice. Returnable by 4 weeks. We'll say 4 weeks.
My lord, okay, my lord, we have no problem there, my lord. But my lord, unless it is interfered, my lord.
Okay. Since Mr. Ingo, since Mr. National Government Advocate appears and accepts the notice on behalf of respondent number 1 and 2, and Mr. Ingo for respondent number 3, no formal notice need be issued. However, the petitioner herself furnish requisite extra copy to both the Rana councils appearing on behalf of the respondents. Staff. Para. Having regards to the contention and submissions of the parties, prima facie, and on perusal of the record, prima facie, this court found that the questions regarding maintainability of the reference proceedings before the learned reference court, in absence of a statutory reference, required proper consideration. Staff. Accordingly, the impugn, the operation of the impugn order.
If I may, Lordship,
Just a minute, I'll say. Impugn order dated. You said it already. We'll say order dated, 21/4/2026.
Order dated 21/4/2026. By order dated 30. There is no point of determination.
If not released, and not acted upon, shall remain state. However, at this stage, Mr. Ingo, Land Council, for the respondent number 3, submits that the order has already been complied, and the Check also has been issued. Check issued
Yes, issued.
to the respondent number 3.
Check issued to respondent number 3. C, my lord. The conduct C, my lord.
No, Lordship, there was no any interference from the higher.
My lord,
Since the
my lord,
has already been
my
deposited before
my
reference
submission
authority.
is, my lord, clear.
And Lordship, if
Please let me complete my submission, my lord. There is complete absence of jurisdictional foundation, my lord. That's why this judicial malice is clear, my lord, here. Order was passed on, the application was filed on 20th, my lord. Order was passed in debilist haste.
When it was released?
20.
Released on 5th of this month.
See, my lord. Whereas there was no jurisdictional foundation, my lord, in absence of this statutory reference, my lord.
Okay.
No, if the submission of a learned counsel for the petitioner is to be considered, Lordship, then section 100 of the act itself, but the petitioner to approach before this honorable court.
Yeah, this seems something which probably is questionable.
My lord.
Because the petitioner, they don't have any local standard as per section 100 of the act.
No, that will be considered only, but then you see the basic requirement, the notice should have been issued to at least to.
No, Lordship, this order was passed in continuance of the order passed by the Deputy Commissioner, Lordship, on 9/7/2025, Lordship. That was not press reference, Lordship.
That was not a reference at all, my lord. That was a disposal, my lord.
But then knowing that he is also interested person.
No, Lordship, he is not an interested person. Lordship, only serial number 1558 of their petition itself clear, Lordship. Their name is not reflected, Lordship.
So unless proof, this court, it will be difficult for this court to
Yes.
believe it.
Their name is not
Unless
reflected
proved.
in the list of beneficiaries.
Unless proved and certified.
Yes, your lord.
Prima facie, it appears.
Lordship.
So that should not be actually, not should have been. And then you don't withdraw from the bank now.
Yes, my
Lordship, that is not my.
Yes, my lord.
Lordship, that observation may not be, Lordship, since again that is
my lord.
another
My lord.
aspect.
That is
Create again prejudice to the.
Since, my lord, jurisdictional foundation has been.
Since, Lordship, that the petitioner, they don't have, they did not make any pleadings.
Absence
So
of jurisdiction.
why should people play?
The relief cannot.
Prima facie, it appears.
My lord.
So what is the hurry?
Yes, Lordship. Lordship, in terms of judgment rendered by the apex court.
What was the urgency?
In Akela
Such urgency.
Lalita versus Sri Konda, Lordship, relief cannot be granted beyond the pleading. Lordship, that pleading is not made in.
In view of the above, the money, the money already released to the petitioner, the respondent number 3 shall be subject to the outcome of this petition. Okay.
My lord, he will withdraw, my lord, in that case. He will withdraw, my lord, in that case. My lord,
Lordship,
because we have clear.
That prayer is not.
What I'm saying is subject to, when we say subject to the outcome,
my lord,
already released, now it is subject to outcome. He should understand now at least.
My lord.
This is matter after four weeks. Okay.
Deeply.
Yeah.
Item number 9.
Anyway, we are grateful, my lord. At least this judicial notice has been taken, my lord. We are deeply obliged, my lord.
Please, Mayor.
Yes.
My lord, yesterday, the respondent 2, 3, and 4, they have filed the additional affidavit. So I may be allowed to file the rejoinder.
Okay, Mr.
Kodappa. I'm on behalf of Senior Counsel
You are
Kititara.
appearing on behalf one in the screen? Online?
My lord,
Are
I'm
you appearing on
behalf?
His respondent number 2, 3.
2, 3,
For the
4. We have
petitioner?
filed our-
No, for respondent.
Okay, respondent.
responded.
Okay,
2-3.
Mr. K. Appa,
Enver.
Land Council for the petitioner submitted. He has received the affidavit in opposition filed by
Additional affidavit.
Additional
Additional affidavit.
affidavit filed by whom?
Filed by the respondent number 234.
Respondent number
234.
2, 3, and 4. And would like to file affidavit in reply to the affidavit in additional affidavit so filed by the respondent. Therefore, he prays for how much time? 3 weeks time. 2 weeks.
2 weeks may be
2
given.
weeks.
Interim may be continued.
The prayer is allowed. Start.
My
Your
lord, may we
respondent
please
number
to-
1. Have you filed? Not yet filed.
So far, he has not filed there.
Sir, you are praying for how much time? No.
My lord, his
Okay.
may not be
Respondent
required.
number,
Not be
affidavit
required.
of respondent number.
Okay, okay,
Format
Mr.
will be not required, madam.
It's a, okay, DSG, okay, Mr. Kato Lane Council, Lane DSG. You are standing counsel for IOC?
Yes,
Yes,
he's,
my lord.
Okay, his name, huh?
N. Barwa.
Mr. Okay, Anbara, Lane standing counsel. Okay, Mr. Kato DSG for respondent number
One only.
1 and Mr. So-and-so Barwa for standing counsel IOC are also present. Okay. As prayed for, comma, list is matter after 2 weeks. Stop. The interim order passed earlier shall continue till the next date of listing. Okay.
Grateful, my lord.
My lord, can it be on 28th of May, if I may, subject to your lordship's convenience? 28th. May,
28.
28th. Other matters are.
Okay. Okay, 28.
Obliged.
Item number 14.
This matter, lordship, pertains to my suspension. I am challenging the suspension order.
Yes.
Even after expiry of 90 days, my suspension order was not reviewed by the responding authorities.
When a notice was issued?
Yes, lordship.
No office note, nothing? Or it's only the, okay, state is the respondent, only?
Yes, only state, lordship.
In this regard, your lordship, our affidavit is almost ready, so at least 1 week may be given, your lordship.
Okay. Ms. Pango, Lana Council, Lana Government Advocate for the state respondent number?
1 to 5, your lordship.
All the state respondent number 1 to 5. Submits that the affidavit is almost ready and will be filing very soon. I will be filing shortly, therefore pray for further. How much time you said?
1 week, your lordship.
For 1 week time. So the prayer is allowed. Mr. Glolin Lani Council for the petitioner is also present. Stop age, prayed for, comma. List is matter after?
Lordship,
1 week.
after 1 week, I am trying for listed on 20, lordship. My lordship.
20.
20.
Okay, lordship.
Okay.
20.
Age, prayed for, comma. List is matter on 20. Okay.
Item number 15.
Lordship.
Same, your lordship.
Same petitioner.
Similar order.
Here,
Similar
lordship,
order, your lordship.
on considering the grounds, lordship, on last occasion, my lordship has directed the respondent authority for payment of subsistence allowance. But I have not received, yet not paid, lordship. So
There is an
for
order.
expedite for subsistence.
There is an order,
Lordship.
Ms. Pango.
Yes,
Uh,
your lordship.
instruct them.
They have not provided certificate, your lordship.
What certificate?
Non-employment certificate,
Yes,
lordship.
non-employment certificate. They have not.
And then requirement you have to fulfill.
Lordship, I have already furnished. Before filing,
Then
now.
In our affidavit, your lordship. So at least 1 week time may be given, your lordship, for filing out.
Okay, similar order then.
Yes, similar.
Okay.
Your lordship.
Matter be fixed on 20, lordship, same.
20.
Connected matter.
20.
20.
Obliged, sir.
Deeply obliged.
See, if it is not possible on 20, you have to say now only. Unnecessarily don't let
Yes,
it.
after 1 week, your lordship.
Yes.
Our affidavit is ready. your
Ready,
lordship.
Okay, okay, then it's fine.
Okay.
Item number 19.
Deeply obliged, lordship.
May I please,
Yes.
Well, 19 is a contempt petition, my lord. My lord, in this matter, as per the service report, my lord, we have implemented new respondents.
Okay, 5 is
And-
also still awaited.
5 is BRTF and commandant.
Okay.
So it's
Otherwise, you have
so-
taken steps.
Otherwise, we have taken steps. Now the issue in this contempt petition is that direction was to pay the solatium after recalculating the compensation
Mhm.
which has been already paid.
Mhm.
So that all has been processed, but then only the approval of the state government, and then the payment has to be done by respondent number 5. But then there is also corresponding which it says that the state government should now. There were one matter pending in the Supreme Court, that is state versus Mehin Lalin.
Hmm.
It was disposed of. And as per the direction, only non-payment was that the bar was the only for. It was not bar for the.
The authority.
Which is pending,
Okay.
and then which is pending, and even before the authority. That was also to be considered. But in our case, it was concluded. I mean, direction was that solatium has to be paid, and they have not challenged our writ petitions. Judgment and order. It has reached a finality. So, but then they are not taking any steps. That only we file a contempt petition.
Who appears for the other respondent? Let's step in for respondent number. Not yet filed. Affidavit filed
Yes.
already.
Yes.
And you are for
I'm for respondent number 2, Commissioner Land Management.
to file already filed?
Yes, yes. We have also filed additional affidavit.
Okay. Have you seen the additional affidavit? Have you received, Mr. Mao?
Additional affidavit filed by. Yes, we have
Okay.
received.
Any response to that? No.
They are saying that Supreme Court judgment is against us. So we cannot pay the compensation. That is
It has to be paid by respondent number 5.
that's one of 5 years.
5 is still awaited.
Still is
What do we
awaited.
do with that then?
Malat, because the process has to be done by the state government, and then payment has to be done by respondent 5.
So wait.
We can wait for some time, Malat. Date may be fixed, Malat.
Okay. Mr. S. Mo, Planning Council for the petitioner. Also heard Mr. Freedom. Planning Council appearing on behalf of Mr. S. Tapping for respondent number 1. And Mr.
N. Norbu for respondent number 2.
Norbu for respondent number 2.
And no one is from
The
respondent number.
service upon the respondent number 5 is still awaited. In view of the above, let this matter be listed in view of the above and as prayed for, let this matter be listed again on.
Malat, before that, Malat, respondent number 6 and 4, they have filed affidavit, but then I don't know who is appearing on behalf of respondent number 6
No one
and 4.
appears on behalf of the respondent number 6 and
6.
4 and 6.
4 and 6, yes, Malat.
4 and 6.
And
And
in the case
the-
of 4, the service is complete, Malat.
Okay. Although no one appears on behalf of the respondent number 4 and 6, although the service upon them is complete. Further, the office note dated 7/5/2026. Like 7/5/26. Reflect that the service upon the respondent number 5 is still awaited. Stop. In view of the above and as prayed for, list this matter on.
Malat, date may be fixed, Malat. May June, Malat, maybe fixed. on
June 1. 3.
June 3. June 3. Okay.
June 3. Okay.
Obliged.
Item number 20.
Yes. Yes. This is
Your Lordship,
affidavit. No,
yes, we have.
Okay, filed.
For respondent number 4, 5, and 6, I have already filed.
Okay.
For 3 also.
3 also.
My lord, CBI has also filed my lord affidavit, my lord.
Okay, well, list
Now-
it, get it listed then in admission, for admission.
Yes, my lord.
Add Mr. Kato, land counsel for the petitioner stuff.
No, my lord, I am for the CBI, my lord.
Oh, CBI. Who is for the
Peti-
petitioner?
Petitioner, my lord, the T. Gyadi and
Is
A.
not
Sharma.
present.
Not present today, my lord.
Oh, none appears on behalf of the petitioner on call. So however, CBI, who is 1, 2?
I am for respondent number
Okay,
7 and
Mr.
8, my
Ram.
lord.
Land counsel for
1, 2, and 3.
land government advocate for state respondent number 1, 2, and 3, and Miss Miss Anju for respondent number
4, 5, 6.
4, 5, and 6, and Mr. Kato for respondent number 7.
And 8.
7 and 8 are present staff. Huh? Since the pleadings are complete, let this matter be listed for admission. After 3 weeks, 4 weeks?
3 weeks.
3
4
weeks. Okay.
Obliged.
Item number 22.
Mayor, please, Lords.
Yes.
My lord, in this case, my lord, the service upon respondent number 4, my lord, is still awaited, my lord.
Okay.
My lord, I may be given, my lord, I may be allowed to take press step upon respondent number 4,
Okay.
my lord.
In view of the office note dated 19/11/2025, Mr. H. Lampo, land counsel for the petitioner, play for allowing him to take fresh steps upon the respondent number 4
My lord.
by way of.
My lord, raise the postment.
Okay. Stop the prayer is allowed. Press steps upon respondent number 4 by speed post as well as by usual process within a week from today.
My lord.
Okay. List this matter after. Or Mr.
3
Okay,
weeks.
Mr. El Parme, Laner, standing counsel for.
I am praying some more time, my lord, to file opinion of
Okay, okay. Also, praise for further, how much time would be required?
3 weeks, my lord.
Further 3 weeks time to file affidavit in opposition on behalf of respondent number
1, 2, 3, my lord.
1, 2, and 3. So, okay, then, yes, pray for, and in view of the above, and edge praise for, comma, list this matter after 3 weeks. Okay.
Obliged.
Item number 27.
Please, Your Honor. May it please, Your Lordship. Your Lordship, kindly pass over this matter at lunch break.
Pass over.
Yes.
Who is the counsel? Who will be?
The leading counsel is Advocate Morik Bagra.
Okay.
Yeah, he's at the washroom.
Okay, he's
currently.
on left. Okay, then, this is the last item. I
Nice,
think.
my lord.
Some other day then.
Yeah.
So leading counsel is at the washroom
We
currently.
cannot. Oh.
Currently
Okay,
at the
let him
washroom.
come then. Huh?
Yes, after
What is this matter about advice?
My lord, he has been terminated and he is also retired, my lord, from the service, my lord. Central government, my lord.
In the what capacity?
And assistant engineer, my lord, in the grave, my lord.
Okay.
Department of BR, my lord, border road. My lord, during the course of service, my lord, the departmental inquiry was conducted and found him guilty in derailing his duty, my lord.
Okay.
And accordingly, my lord, the department has imposed some penalty, my lord. During the
It says that additional affidavit not yet filed also.
My lord,
On behalf of the respondent, additional affidavit you wait to file.
additional
it appears.
affidavit, my lord, may not be required because the subsequent there is a
Now you are no longer filing then.
Yes, my lord. Subsequent development has been taken, my lord. In other ways, my lord, on the last occasion also, my lord, I prayed for, my lord, the dismissal of this petition, my lord. Considering the facts that, my lord, the department has concluded, my lord, departmental inquiry, yes, my lord.
Hmm.
And impose the penalty of, my lord, by withholding, my lord, 25% of the monthly pension otherwise admissible to him for a period of 3 years on so-and-so, retired. The gratuity admissible to him may be released, my lord. This is the final
Anyway,
order.
let him place his case. So because praying for setting aside the disciplinary proceeding itself, no? And also the inquiry.
Well, disciplinary proceedings cannot be, my lord, set
No,
aside as because
So
when there is
okay,
allegation.
let him place his case. Okay. Let's pray for Kama. This is next week, we'll say.
Yes, my lord. For me, my lord, I'm available, my lord. Subject to convenience. No, my lord. My brother is always pressing
Okay,
hard
list
for.
matter. Next week. Okay, tell him that next week.
Master Bless you.
Who will take up on opposing? Okay, next week. On it will be placed on next week Thursday.
My lord.
So that we keep. Okay.
Deep
Master Bless you.